So I've been talking about notices oft in my presentation. This is where the notice and the consent, and I think these are the last two sort of clauses that I'll talk about, and then I'll wind up. So notice to data principal. Sorry. Uh, a notice is required to be sent to the data principal to ensure the data principal understands what data will be collected, why it will be processed, how it will be used, and what rights the data principal has. So, so before you give your consent, the organization has to give a notice in some form, electronic or physical or embedded in certain procedures or SOPs, etc., that we are collecting or we will be collecting this data. This is how we will process it. This is how we will use it. These are your rights. These are the grievance redressal mechanism, etc., etc. And you will have all that information before you give your data. So this is a notice. No processing is lawful without a valid notice, right? Except certain legitimate uses, which are the exemptions that we talked about. Or for example, one of the exemptions was like even in the banking, like you open a bank account and they are governed by RBI, that's a regulated sector, and they have a KYC requirements. So so they don't need a separate valid notice because that KYC requirements, regulations, so that's very clearly providing the exemptions. But what I'm saying is otherwise, you ought to get a notice and you need to give a consent and then the data flows. So you will see in the next 18 months organizations exploring that one, what data will be used or what data will be collected in the first place, from whom, etc., etc. And how will we give the notice? Will it be electronic? Will it be through some agreements? Will it be a specific form or what kind of notice will we give? And when must notice be given? Before or at the time of obtaining consent, and in case of legitimate use, as soon as practicable, and consent obtained without a prior notice is an invalid consent. Now, you may also say that you already have so much of data, either of employees or customers or vendors. Are you still going, going to give a notice to them? So the answer is yes. Even if you are retaining certain data as on the the commencement of the effective date of the provisions, you still will have to give the notices to the data principals, right? Mandatory elements. So again, the rules specify all of this: personal data, specified purpose, manner of processing, how to exercise your rights, how to withdraw consent, etc., etc. It must be precise, unambiguous, and easily understood. Format and delivery could be anything: clear, plain, simple, prominently displayed, is accessible on your maybe pages, pop-ups, apps, etc. If the user cannot find the notice, the data fiduciary is non-compliant. See, such a blanket statement. So it cannot be a clandestinely, secretly put in as a clause in a long agreement, and can't. It has to be very clearly placed in a position where it is identifiable. Because if you can't find it, maybe the data fiduciary can be fined by the regulator, saying it is misrepresented, representing, you're intentionally hiding it, etc. Treat it like a disclosure, just like when the companies are going for IPO, you see what kind of disclosures and what kind of strict guidelines for SEBI, LODR, or those kind of guidelines are. And even in just on a lighter note, an analogy, so for example, the statutory warnings on cigarettes or those kind of things, 60% of the pack is covered with this causes cancer, so you can't miss it. So it's like that. So the data fiduciary, DF means data fiduciary, must update the notice if purpose changes. So you had a notice, but now the purpose has changed, or you are changing anything with respect to collection of the data, or you are giving this to new data processors, etc., or you're changing anything with respect to that, you must give a revised notice. Notice plus consent. As I said, notice is prominent, consent button is clear and separate, no dark patterns, misleading interfaces.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. all in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.